Hello, everyone. Before we dive deep into studies, it's highly recommended that you have a pen and notebook ready to take necessary notes for your learning journey. Please note that there may be a disparity between the visuals and the audio points. For an accurate interpretation, I would appreciate if you could prioritize the audio content only. Remember, if there's anything you don't understand, feel free to pause the video, rewind, and listen again carefully. We often use the terms jurisprudence and legal theory interchangeably, but they were not originally the same study. The difference is rooted in history and focus. Jurisprudence is the older, broader term traceable back to the ancient Roman jurisprudentia, meaning knowledge of law. It traditionally serves as the systematic analysis of law, examining the actual positive rules that exist, classifying them, and finding the general principles that hold the legal system together, like studying the structure and anatomy of law. Legal theory, on the other hand, is a newer concept. It's a field dedicated to the philosophical and evaluative side of law. It asks the critical why questions. What is the purpose of law? Is it just? This approach links law directly with deeper concepts of philosophy, ethics, and political theory. While jurisprudence focuses on what the law is, legal theory tackles what the law ought to be. Today, these fields overlap significantly, but understanding their original distinction clarifies the two primary ways we think about legal systems. Now we will learn about the two ways to think about law: jurisprudence and legal theory. People use the terms jurisprudence and legal theory as if they mean exactly the same thing. In casual conversation, this is fine. But when we look closely, especially in law school or while reading advanced books, we find they point to two slightly different, though overlapping, approaches to understanding law. Think of it like comparing the study of the human body's structure, better known as anatomy, versus the study of its function and purpose, better known as physiology. Let us first know the historical difference. The difference between these two terms is rooted in history. The word jurisprudence is the older of the two. It comes from the ancient Roman term jurisprudentia, which simply meant knowledge of law or skill in law. For centuries, this term was used, especially in places like Britain, to describe the systematic way we study the actual existing rules of law. The term legal theory, on the other hand, is a much newer invention, only becoming common in the last century. Its creation signaled a desire to focus specifically on the philosophical questions about law, the kind of questions that go beyond just reading the rules and start asking why those rules exist and whether they are fair or good. So, while jurisprudence traditionally focused on analyzing the law, legal theory focuses more intensely on evaluating the law. Although today's textbooks often use the title Jurisprudence and Legal Theory because their subject matter has largely merged, understanding their original distinction helps us grasp the core focus of each field. Now we will talk jurisprudence as the anatomy of law. If we consider law as a machine, jurisprudence is the study of how that machine is built, what its parts are, and how those parts fit together logically. So we have to know the core focus of jurisprudence. In its traditional form, especially among 19th century British legal thinkers, jurisprudence was the systematic study of positive law. Positive law simply means the law that has been formally set down, passed, or enacted by a recognized human authority, like a parliament or Congress. Jurisprudence takes these actual existing laws and works to analyze them, classify them, and find the general principles that tie them together. It wants to organize the legal system into a neat, logical framework. It covers a wider area of study compared to pure legal theory, as it delves into many different specific legal concepts, like the nature of a right, what constitutes a duty, or the meaning of possession. Theories of causation in law helps a judge by providing different logical frameworks. Example is the but-for test, the proximate causes test, to interpret and apply that vague term consistently in a trial involving a car accident or professional malpractice. Third is the scientific development of law. So what is the explanation? Jurisprudence doesn't just study existing law, it aims to make it better and more logical. By breaking down the legal system into its parts, we can spot inconsistencies, overlaps, and outdated rules. This process allows for the scientific development of law. Real life example. Many legal systems are currently struggling to deal with the rise of artificial intelligence, AI. Jurisprudence systematically analyzes existing laws on liability, contracts, and intellectual property. It then helps lawmakers determine, for instance, who is liable when an autonomous vehicle causes an accident, the owner, the programmer, or the AI itself? This study is not philosophical, legal theory. It's structural jurisprudence, aiming to fit a new technology logically into the old legal framework by changing or creating new logical rules. Fourth is the developing critical faculties and understanding terminology. So, the explanation is studying jurisprudence sharpens the minds of legal students and professionals. It forces them to think abstractly and logically, which develops their critical faculties and ensures a proper understanding of complex legal expressions and terminologies. Real life example. In criminal law, a student needs to understand the difference between motive and intention. A person's motive might be good, for example, stealing medicine to save a child, but their intention, the immediate goal, stealing, is illegal. Jurisprudence provides the precise theoretical framework to logically separate these two concepts, which is critical for correctly determining criminal guilt in court. Fifth is the highlighting fundamental principles in society. So the explanation is jurisprudence throws light on the basic and fundamental principles of law in a given society. It reveals the core beliefs the legal system is built upon, such as the separation of powers or the equality of citizens. Real life example. A comparative law scholar is studying the legal systems of a democratic country and an authoritarian one. They use jurisprudence to identify and analyze fundamental concepts. For instance, in the democratic state, the principle of rule of law is fundamental, meaning everyone, including the government, is subject to law. In the authoritarian state, the fundamental principle might be the absolute and unlimited sovereignty of the leader. By studying the structure of their laws, jurisprudence reveals these distinct foundational ideas. Now, we will discuss the legal theory, the philosophy of law. If jurisprudence asks, how is the machine built? Legal theory asks, what is this machine for and is it serving a good purpose? So, the core focus of legal theory is the essential task of legal theory is to examine and analyze the philosophical content of law. It is primarily concerned with the nature of law itself and its end, its ultimate goal. The key difference is that legal theory is evaluative, normative, and idealistic. Evaluative means it judges law, asking if it is good, fair, or moral. Normative means it deals with what the law ought to be, not just what it is. Idealistic means it often holds up an ideal vision of justice against which current laws are measured. As the text states, all systematic thinking in legal theory is linked to philosophy, our reflection on humanity's place in the universe, and political theory, our ideas about the best form of society. For example, a theory might start with a philosophical idea about what makes a human being valuable, and this idea will then shape the kind of rights, political theory, the law grants to that human being. Before the 19th century, this field was just a side project of philosophers and churchmen. Now, it is an independent field where lawyers directly confront problems of social justice in their legal work. Now, 5 real-life examples of the task of legal theory. Legal theory provides the critical lens through which we judge the moral and political worth of the law. Here are 5 practical ways it is used in the real world. First is evaluating laws based on morality and justice. So, the explanation is, legal theory uses concepts of ethics and justice to judge the law. It's not enough that a law was properly passed. It must also be just. This requires an evaluative and normative approach. Real life example. During the mid-20th century in the United States, there were laws that mandated racial segregation, apartheid laws. Jurisprudence would confirm that these were valid, positive laws because they were passed correctly by the legislature. Legal theory, however, using natural law philosophy, declared these laws fundamentally unjust, immoral, and contrary to the end of law, which is justice. This philosophical challenge eventually helped drive the civil rights movement and the legal dismantling of segregation. Second is exploring the role of government, political theory. So the explanation is legal theory examines how core political ideologies like liberalism, socialism, or classical conservatism influence the creation and goals of the legal system. It studies how the law is used as a tool to achieve a certain vision of the best form of society. Real life example. Consider laws regarding economic regulation. a legal theory rooted in socialism would argue that the law must be used to heavily regulate markets, redistribute wealth, and ensure state ownership of key. Now, we will talk about the blending of disciplines. In the end, while their starting points were different, jurisprudence as the systematic analyst and legal theory as the philosophical evaluator, their fields have merged significantly. Today, a legal scholar cannot effectively analyze the structure of property law, jurisprudence, without also considering the ethical implications of ownership and distribution, legal theory. Their work is now seen as two sides of the same coin. One side focused on the logical coherence of the rules, and the other focused on the moral justification of the system itself. This combination is why the subject is now studied as a single, comprehensive field, preparing future lawyers not just to follow the rules, but to think critically about their ultimate purpose. Now we will lean jurisprudence and legal theory, a clear distinction. Imagine law as a magnificent, sprawling building. We can study this building in two major ways. We can study the blueprints, materials, and structure, how the foundations are laid, how the walls are connected, and how the wiring system works. This systematic structural study is like jurisprudence. Or we can stand back and ask, what is the purpose of this building? Should it be a home that shelters and provides warmth, or a fortress that keeps people out? Is the structure safe and morally sound? This philosophical and evaluative study is like legal theory. While people often use these terms interchangeably, especially since the fields have merged, they point to different kinds of investigations into law. The core difference lies in their scope and their focus. Part I, we will talk about jurisprudence, the wide-angle view and analysis. Jurisprudence is the broader field. Think of it as the parent discipline. It is an abstract, general, and theoretical investigation that aims to uncover the essential principles of a legal system. Its goal is to take the vast, chaotic sea of laws, known as positive law, and bring structure to them. It helps us understand the fundamental concepts like what makes a rule law, what different kinds of rights exist, and how a duty is enforced. Jurisprudence covers everything from the specific analytical study of contracts to the general philosophical inquiries about justice. It involves taking the law as it exists and making logical sense of its entire framework. The traditional British concept of jurisprudence often focused heavily on this analytical aspect, defining the supreme lawmaker sovereign, analyzing their orders, commands, and studying the power to enforce them, coercion. This approach was often criticized by modern thinkers like Dr. Friedman for being too technical, like studying a machine's parts without asking what it's supposed to make. However, jurisprudence remains the wider subject, seeking to lay bare the essential principles of the whole system. So, 5 real-life examples of jurisprudence in action. Second is the debate over human rights, philosophical foundation. Oh, so the scenario. Nearly every nation recognizes human rights, like the right to life or the right to freedom. But where do these rights come from if they aren't written down in every country's code? Oh, legal theory's role. Legal theory, specifically natural law theory, examines the philosophical belief that certain rights are inherent to human beings, existing independently of government. This theory provides the idealistic and normative basis for documents like the Universal Declaration of Human Rights, asserting that the law ought to protect these rights because of our inherent status as thinking individuals, not because a ruler commanded it. Third is analyzing the purpose of punishment, the end of law. Oh, so the scenario. When someone commits a crime, legal systems must decide how to punish them. Should the focus be on vengeance, deterrence, or rehabilitation? Or legal theory's role. Legal theory analyzes the end, values, and goals that punishment should subserve. For instance, utilitarian legal theory argues that punishment's sole purpose should be deterrence, reducing future crime for the greatest good. In contrast, retributive legal theory argues that the purpose is purely justice, punishing the wrongdoer simply because they deserve it. This philosophical debate shapes everything from sentencing guidelines to prison reform policies. Fourth is law and political ideology, shaping society. Oh, so the scenario. 2 different nations create constitutions after a revolution. One adopts a strict capitalist market economy, and the other adopts a socialist economy. Oh, legal theory's role. As stated by Friedman, Legal theory gains its color from political theory. Theories based on socialism argue that the law's end goal is economic equality, necessitating laws that control property and redistribute wealth. Theories based on laissez faire capitalism argue that the law's end goal is maximizing liberty, requiring minimal economic regulation. Legal theory analyzes how these fundamental political blueprints translate directly into specific legal systems. Fifth is confronting social injustice, the felt needs of society. Oh, the scenario. A society realizes that its criminal justice system disproportionately affects certain minority groups even if the laws appear neutral on the surface. Oh, legal theory's role. Modern legal theory, particularly movements like critical legal studies, rejects the purely technical perception of law and focuses on felt, needs, and social forces. It asks, is the law achieving true social justice? This evaluation forces lawyers to confront the gap between the law as written jurisprudence and the law as it is experienced, legal theory, leading to demands for profound reform based on equity and moral obligation. So, always remember the core difference. Jurisprudence is the systematic anatomy of law, analyzing what the law is, its structure, principles, and concepts, giving us the essential toolkit to be effective legal practitioners. Meanwhile, legal theory is the philosophical physiology of law, evaluating what the law ought to be, its morality, justice, and ultimate purpose, providing the critical lens to challenge and improve the system. Though once separate, they are now inseparable. One provides the logical coherence needed for the system to function, and the other provides the moral justification needed for the system to endure and serve justice. Mastering both prepares you not just to follow the rules, but to be a thoughtful architect and critic of the law itself. That's all for now. Thanks for watching the whole video. If you enjoyed it, please comment in the comment section below. Legal theory is wow. Hit the like button, share it with your friends, and do subscribe to the YouTube channel, Knowledge Drops 3. Also, don't forget to click that notification bell so you'll know right away when I upload a new video.